Good morning, Miss. I am Wong Win Yan, and I will start off with the introduction first, which is the definition of land. According to Section 205, subsection 1, 9 of the Law of Property Act 1925, which is the LPA, land includes land of any tenure and mines and minerals and buildings or parts of buildings and other corporeal hereditaments, also a manor and an ocean and a rent and other incorporeal hereditaments and an easement, right, privilege, or benefit in, over, or derived from land. Next, I'll be talking about difference between lease and license. So for lease, it gives an individual the right to control the property, while license gives an individual the right to act on it. If a valid lease is formed, Section 52 of the LPA, which sets out the rule of formality of a legal lease, must be established. Lease can only be terminated subject to the terms of the agreement, while license is revocable right. It can be taken away depending on the terms of the license. Lease has right to ownership of the property, including the right to keep any percent of the property, while lease do not have any right to exclude owners. Lease can be transferred to third party but not licensed. Following, I will explain the definition of lease. A leasehold is defined in a section 1, subsection 1b of LPA as an estate in the land for a term of years absolute. A lease is a contract between a tenant and a landlord that provides the tenant with exclusive interest in the property. A lease may bind any subsequent owner of the reversion since it is recognized as proprietary interest in the property itself. Furthermore, leases are subject to the statutory regulatory framework of the Housing Act 1988 and the Rent Act 1977. Next would be the creation of lease. According to Templeman's judgment in Street against Mountfort, they have three requirements, which is exclusive possession, rent must be ordinarily paid, and third, certainty of term. So I'll start off with exclusive possession. It is the right to use the premises exclusively, even to the exclusion of the landlord. In Macau against Da Silva, the court held that there was no exclusive possession as the agreement required the landlord to provide attendance and services, which would have required unrestricted access to the premises. Gibson Alger further explained there is no exclusive possession where a room is occupied and controlled for the purpose of fulfilling an attendance and service duty that has been agreed upon with a landlord. Moreover, the courts ruled that the services given by the landowner does not negate exclusive possession provided that the service must be presented. According to Aslan against Murphy, the tenants were asked to vacate the premises at certain periods during the day, and this did not negate exclusive possession. The courts held that it proved exclusive possession because the contracted term was needed to ensure that the tenants left the premises at the pre-designated periods and not because the landlord had unrestricted access to the property. The court also stated that the occupier would be deemed as a lodger if the keys were kept for services such as daily bed making and cleaning. In other words, there will be no exclusive possession if the service that's stated on term C is provided. The next issue to point out would be the fact that Aaron has the right to have his choir practice every Saturday afternoon at the flat and ask Marcus and Penelope to vacate the property. In principle, there is a significant distinction between exclusive possession and exclusive occupation. The parties' right govern exclusive possession, whereas exclusive occupation is a question of a fact. Based on term D, they might have exclusive occupation but not exclusive possession. They are advised to argue that this is a term that has been introduced with the specific intention to avoid the creation of a lease. Firstly, Marcus and Penelope were asked to sign the license agreement in which there is a possibility for a lease to be present. According to Templeman's judgment in Street against Mountfort, an agreement which confers on an occupier exclusive possession for a term at a rent creates a tenancy even if the agreement is phrased in terms of license. In other words, even if it is explicitly stated, the landowner cannot avoid issuing a lease by simply referring to the arrangement as a license, as labels are not decisive. In such cases, the court will disregard the label given by parties and relabel the arrangement according to its true character. In Antonius against Villiers, the tenant had included the terms in the agreement that were unlikely to be enjoyed in practice, including the right to spend the night in the property. It was held that it was practiced and the clauses were struck out and the lease was given effect without the offending clauses. The House of Lords held the agreements to be shams, both from their wording and negotiations, which preceded them in the sense that they were a smokescreen for the real relationship between the parties. Therefore, it can be submitted that the term D of the agreement, whereby Aaron has the right to utilize it every Saturday afternoon, should be struck out and the lease to be granted to Marcus and Penelope if term D presented in reality as in the principle under the Markel case. The second element would be rent must be ordinarily paid. Lord Temperman incorporated the term rent in his definition of a lease in Street against Mountford, but strictly pointed out that it is unnecessary. Section 205, subsection 127 LPA sets out the definition of terms of years as if or without rent. It was affirmed by Temple's main judgment in Ashburn and Starr against Arnott that rent is not essential for the existence of a lease, but is usually indicative of an exclusive possession, so its absence would need an explanation. The only requirement to be fulfilled as a rent is the amount of rent must be capable of being ascertained with certainty. In Bostock against Bryan, the obligation to pay utility bills could not be regarded as rent. Therefore, based on term A with a payment of £1,000 per month would be sufficient enough to validate the second element of the requirement of a lease. Last would be certainty of term. The duration of term must be determinable as clarified in Prudential Assurance against Waterloo Real Estate, and as identified, the beginning, the duration, and the end date of a lease must be ascertainable. The commencement date must also be decided in the agreement to create a valid lease, as held in Harvey against Pratt. Based on the question, it can be ruled that Marcus and Penelope are allowed to stay until such time as England wins the World Cup provides no specific duration. According to Lace against Chandler, the court held that it was not a fixed lease. The term granted had to be certain from the outset, and the duration of war was not certain. Therefore, the element of certainty of duration is not satisfied in term B. Next, I'll be explaining the definition of license. A license is defined in Thomas against Sawyer as a personal permission to use land belonging to another that, without such permission, would amount to a trespass. The essence of a license relating to land is that it confers on the licensee a right to occupy or use the land in question without granting him a proprietary interest. The right of the licensee may only be invoked against the landowner when the licensee access rights have been unjustly violated, as they are vested in the licensee and not the property. Following is the creation of license. The creation of a license is not subject to any formal requirements, and license may be created orally, in writing, by a deed or registered disposition. Licenses are not inherently proprietary. A license is a right over land rather than an interest in it. As a consequence of being personal, the right conferred by a license can be enforced only against the person who created it. License is not within the realm of real property and is incapable of binding third parties when the licensor transfers the burdened land. If the licensee and licensor are parties to a contract, then the standard principles of contract law regarding remedies and damages apply. There are three types of license. First, bare license. Second, license coupled with an interest. Third, contractual license. For the first one, bare license is permission to enter upon land given voluntarily by landowner who receives nothing in return. Giving of license is gratuitous since it is not supported by consideration moving from the licensee. There is no contract and can be given in any form. It lasts as long as the licensor desires. Next, license coupled with an interest. Landowner may grant another person a profit over land that is a right to take from land some natural resource. In order to exercise this profit, the grantee must be able to enter upon the land and remain there for an appropriate time. Last, which is the contractual license, it is founded upon valuable consideration by the licensee for the benefit of the license. Examples are purchase of cinema ticket and occupation license. The terms of a contractual license are that for a certain period of the licensee may enter on the licensor lands lawfully. Thus, a contractual license is governed by ordinary rules of law of contract. Contract may be either expressly or implied. It does not bind to third party as affirmed in Ashburn and Stott against Arnott. Based on the fact that Marcus and Penelope signed the license agreement, which is entitled to a contract, Marcus and Penelope pay a license fee of £1,000 per month, which considered as a valuable consideration, and the term of the contract provides that the license is to end upon the occurrence of the event of England wins the World Cup. Thus, it could be determined that they have entered into a contractual license. So, can contractual license bind third party? From the traditional will, Ashburn and Stott against Arnott stated that a contractual license does not create a property interest, meaning it is not binding on third parties. However, the courts have reconsidered the extent to which a license may be capable of binding third parties. In Errington against Errington, it was held that under the equity law, only a bona fide purchaser without notice was not bound. Although Zane has informed Marcus and Penelope that they have to leave the flat by the end of the month, it is still arguable whether Zane is innocent of not knowing their existence before she bought the property from Aaron. Therefore, it would not be binding on Zane if she is an innocent party who purchases property without notice to the title of the property. Next, I'll be talking about the remedy part. Depending on the terms or clauses, the court may conclude that the license is irrevocable, revocable at will, or revocable on the giving of a period of notice. As regards contractual license, Lord Porter determined that the question of whether license is revocable must be determined by the terms of the document. Licensee must be given a reasonable time to vacate the premises, and what is a reasonable time must depend on the circumstances of the case. In Winter Garden Theatre against Millennium Productions, it was held that licenses without consideration are revocable at any time. In the current case, the license granted by the appellant was not, however, perpetual. It could be terminated by the appellant on giving reasonable notice. Furthermore, an injunction can be obtained to prevent the licensor from revoking the license before its contracted date of expiry. Based on the facts, Marcus and Penelope were not in any breach of contract. Also, Aaron did not inform his will of revocation or his act of transferring the land to Zane or give a period of notice. Hence, the court may decide whether remedies and injunctions are claimable. Last would be my conclusion. Based on the question, it is submitted that Marcus and Penelope may have a contractual license and it does not fulfill all of the requirements of a lease. Even if the court would strike off the term which is used as a sham device, it is still asserted that they entered into a license agreement as they did not establish a certainty of term. If Zane is a bona fide purchaser, she will not be bound under equity law, and Marcus and Penelope might be unable to continue to stay at the basement flat. Thus, claim of injunction and remedies must depend on whether Zane is a bona fide purchaser. Thank you.